So that is where the safe harbor kind of discussion comes into play. So in the state of Florida, there is a part of the statute, and actually two contained in most governing documents, which is called safe harbor. And basically what it means is that if a bank takes over the property and takes title through a foreclosure or through a deed in foreclosure, a deed in lieu of foreclosure, then what happens is so typically if somebody else besides the bank takes a title through either deed in lieu of foreclosure or through a foreclosure, they're still responsible to pay off all those prior delinquencies. The banks came along and said, hey, we got pretty strong lobbyists, let's go talk to the legislature. So the legislature decided to kind of help out the banks. So what they did is they said, okay, we're going to create this safe harbor. So if the bank follows the proper procedure, which is a big if, because a lot of times associations just assume that the bank has done it correctly when they may not have in fact gone through the proper procedure to be eligible for safe harbor. But let's assume for the sake of argument that they have in fact gone through the proper procedure and the bank forecloses on the property and take title to the property, and then the association goes, hey, wait a second, the prior owner owed $20,000 worth of assessments and now you have to pay. So the bank can go ahead and say, no, we're relying on safe harbor. And what safe harbor means is that, as I stated, if they go through the proper procedure and the proper protocol, the banks are entitled to only have to pay a certain portion or percentage of the assessments. And what is that portion or percentage? It is 1 year's worth of assessments. So let's say that you had assessments at $250 per quarter, so $1,000 a year. So the annual assessment would be $1,000, or 1% of the recorded mortgage. So not what is left, not the principal, the interest, whatever is recorded for that mortgage, that amount. So let's say that amount is, just for sake of argument, let's say that's $150,000. So 10% of the $150,000 would be $15,000. 1% would be $1,500. So in that particular scenario that I gave you, you would have $1,500, which would be the 1% of the recorded mortgage, and you would have $1,000 as 1 year's worth of assessment. And what the statute says is that the bank is only liable to pay the lower of those two amounts. So it would be the $1,000. If the assessments were $2,000 for a year and the recorded mortgage was $1,500, then they'd have to pay the $1,500 for the recorded mortgage. So it doesn't matter if the association is owed $20,000, $30,000. The bank, if they do things right, they get a break and they only have to pay that. Now, once they take title, they have to keep paying, as long as they own the property, regular assessments. They don't get any break from that point forward. And then there's some funky kind of case law that goes along with it. Coral Lakes, which basically states that if there's language in the declaration that says that the banks owe anything if they take it per foreclosure, then does that apply or does the statute apply? And that's a whole different discussion, but that's something that the attorney kind of needs to talk to the associations about. One last thing on that issue is that, so I give a course on certifying new directors in the state of Florida when they become new directors for the condominium or HOAs. And what I tell them when I talk to them about this issue is that be very, very careful just accepting the bank, their offer or demand of paying just what's required under safe harbor, because if you have a large amount as an association that's due, on delinquencies and they make this claim, the bank may not have gone through the proper procedure. And I had a case that was where it was a very exclusive community and the owner had not paid for quite a long time. And the association was kind of waiting to see what the bank was going to do. So the bank forecloses, they claim safe harbor, they wanted to pay, it was right around $1,700. And the association was owed in the neighborhood of 90-something thousand. And so the association was ready just to accept the $1,000 to $2,000 based on the safe harbor. And I said, wait a minute, let me go and check this. And I checked and the bank did not follow the proper procedure. And so that's a huge difference that the association may be giving up if they don't check that area. So it's a really important part of collections for associations.